Hello, and welcome to this series of environmental law lectures from the IUCN World Commission on Environmental Law. My name is Nicholas Bryner. I'm the Emmett Frankel Fellow in Environmental Law and Policy at the University of California, Los Angeles in the Emmett Institute on Climate Change and the Environment. I'm excited to talk to you today about an important principle related to the environmental rule of law, which is the principle in dubio pro natura. In the IUCN World Declaration on Environmental Rule of Law, the principle in dubio pro natura is defined as, in matters of uncertainty before courts or administrative tribunals or other decision makers, matters shall be resolved in a manner that best protects the environment for the interests of future generations, as well as those who may face disproportionate burdens from activities that degrade the environment. One of the most well-known principles of environmental law is the precautionary principle. The precautionary principle has been developed as a way of managing scientific uncertainty about environmental harms. Or in other words, when we're not sure about the state of the science, or there is some uncertainty about whether some human activities might impact the environment in an irreversible way, we should take extra precaution to make sure that we protect the environment for both present and future generations. The principle in dubio pro natura is related in a number of key ways, and I want to talk a little bit about what the principle means, what the justification for this principle is, how it's different from the precautionary principle and some other ideas in environmental law, and then talk about a couple of examples about how it's used in practice. So the principle in dubio pro natura, it comes from the Latin phrase regarding when there's cases of doubt, we should resolve matters in favor of the environment, in favor of nature. The justification for this principle is really a counterweight against a legal and social and political system in which matters involving the environment have not always been properly valued. The justification for this comes from analogies to other principles that we use in criminal law, in contract law, and general principles of the rule of law. As it relates to criminal law, many countries, including civil law and common law countries, have a form of principle in which laws that regulate criminal conduct are interpreted in favor of the defendant or in favor of the accused. In civil law countries, this is known as the principle in dubio pro reo. When there is doubt as to the manner in which a criminal law is applied, or who it applies to, or what conduct it reaches, decisions should be made in a way, when there's doubt or ambiguity in the statute, to resolve them in favor of the defendant. This is because criminal laws pit the interests of an individual, the accused or the defendant, against the interests of a much more powerful state. And we want to make sure that we place a little bit of a buffer or a thumb on the scale in order to better represent or protect those interests that are more vulnerable, that may be underrepresented in the political or legal system, and to ensure that they are adequately protected from the threat of any irreversible harm. In that case, resolving matters in favor of the defendant protects the defendant's right to life and liberty and other critical interests that are important to the individual. In common law countries, we also have the rule of lenity, which was originally developed in England for a strict construction of criminal laws in order to ensure that they're not over-applied. As it relates to contract law, we also have principles that in cases of ambiguity, contracts should be resolved against the drafter or against the interests of the person who drafted the original contract or agreement. And the reason for that is to ensure that one party does not take advantage of another. Whoever has been involved in drafting the contract generally has more knowledge about that and perhaps has had inadequate level of bargaining power, too high of bargaining power in reaching that agreement. So we interpret contractual provisions in a way to ensure that we best represent the interests of the party that may have been underrepresented or undervalued in that regard. And as it relates to general principles of rule of law, consistent with principles of transparency and accountability, and the idea that the law applies to everyone equally, one of the other critical elements of the rule of law is that the interests of those who are underrepresented, the vulnerable in our society, should be best protected. And judges and other decision makers should take extra precautions, take extra steps to ensure that those interests are better protected. And so I speak about those in environmental context, talking about the interests both of current generations and future generations. We know from the field of environmental justice that the burdens of environmental degradation are not felt equally. They're often split across racial lines, ethnic lines, and class lines as well. Those in poverty experience much higher levels of environmental degradation, are located closer to sources of pollution and many other related environmental problems and issues. And as it relates to future generations as well, our current political and legal systems have not adequately taken into account the extent to which our actions as individuals, as humans living on the planet today, the impact that our actions have on and may have on future generations as well. So the principle in dubio pro natura acts in a variety of ways and in a variety of contexts to protect both of these types of interests. So whenever there is some ambiguity about the extent to which a law applies, a statute or a civil code or a constitution, or when administrative decision makers are faced with making a decision where they may have some discretion as to the extent to which a law applies or the particular mandate that they've been given, those decision makers should ensure that they take the decision that is best suited to protect the environment. That may not always be clear in every particular instance, and as I've mentioned, the case of the principle in dubio pro natura really starts from where there is an ambiguity or cases of doubt. It doesn't mean that environmental interests will necessarily always win in every dispute, but it does mean that judges should at least place those concerns at the forefront in making their decision. Administrative decision makers should consider that, along with a host of other principles and other considerations that they're taking into account. What happens far too frequently is that environmental interests are simply not at the table. They're not being considered. They're not up for the matter of debate alongside other principles that judges or administrators use. And the critical aspect of this is to restore some balance for the environment, for environmental interests in making those types of decisions. So let me talk a little bit more specifically about how this applies to judges and give you some examples of how judges have used this principle in a variety of different contexts and in several different countries. So judges use a variety of tools in interpreting statutes. I've mentioned some analogies from criminal law, and they also use these principles in interpreting contracts. Judges have used these tools to put their thumb on the scale for a variety of interests that they deem important. And the principle in dubio pro natura recognizes that environmental interests should be placed on the same platform and should be considered to the same extent that those other interests are as well. In common law countries, and particularly in the United States, we refer to some of these tools that judges use as canons of construction that are used in statutory of interpretation, and particularly substantive canons of construction, which are the types of canons that relate not merely to the grammar or language usage of how you read a particular law, but rather to address substantive matters, substantive values, and policy choices that are made in our legal systems. So let me give you a couple of examples about how this principle has worked in practice. In Brazil, in particular, the National High Court, the Superior Tribunal de Justiça, has used in a variety of cases, a variety of precedents, this principle in dubio pro natura to interpret both environmental statutes as well as generally applicable statutes that deal with other areas of law. So it's not restricted only to environmental laws. The question is, how do you interpret any ambiguous statute that may have an impact on the environment? We would consider what impacts those have on other human rights, so we should also consider the impact that that has on rights with regard to the environment and also rights of nature when those are protected in a particular legal system and to the extent that they're protected. So in one example, the Brazilian National High Court was called on to interpret the Public Civil Action Act. And this is a statute that authorizes public prosecutors and other entities to bring civil actions on behalf of the public interest. And one of the questions was the statute that authorizes these actions allows prosecutors to bring an action seeking either damages, so monetary damages, or injunctive relief. And the term that's used in the statute is or. And so the court was called on to examine the question of whether that was an inclusive use of the word or an exclusive use of the word or. In other words, do you have to choose only one type of relief or another? Now this became really important for environmental matters because if you're bringing an action to seek restoration of an area that has been damaged due to some sort of human activity, whether industrial activity or pollution due to the air or water or some other concern, it's not simply enough to seek damages to restore that area, because that would not provide any incentive or deterrent effect for other actors from taking similar, from causing similar types of pollution or other problems in the future. So it's important in these types of cases for prosecutors to seek not only injunctive relief to protect or to encourage actors to take a particular action to protect the environment, but also to seek damages and a deterrent level of punitive damages as well, in order to make sure that this conduct does not occur again in the future. So courts took this example, and the National High Court was called on to decide whether how it was going to interpret this statute. Was it going to interpret this inclusively in order to ensure that environmental interests were best protected or not? And according to the principle in dubio pro natura, in this case of legal uncertainty, the court opted to make a decision that would lead to better impacts for the environment, both for present and future generations. Other examples of the way in which this has been articulated: in the Constitution of Ecuador, there is a specific principle listed in the chapter on issues related to the environment in the Constitution, that statutes should be read in a manner that's most consistent with the environment. So that's a very clear mandate, even in the country's constitution, for this type of principle. In the United States, we don't have a constitutional principle on the environment. Some state constitutions within the country do. However, we do have some foundational texts, some foundational statutes on environmental issues that lead to this same type of principle. So in the National Environmental Policy Act, which was passed in 1970, the United States Congress established a policy for environmental protection in the United States. And that statute has most commonly been associated with the requirement for environmental impact statement. It requires that before any activity can be undertaken by a federal public agency, that agency needs to undertake an environmental impact study, consider what the alternatives might be and the impacts that those alternatives will have on the environment. But one of the things that NEPA, as the statute is known, the National Environmental Policy Act, also includes is a statement of purpose, which provides some language about how we should craft our environmental policies in order to protect the interests of the environment as it relates to humans as well as others, as it relates to current generations as well as future generations. And what the statute also says is it requires that regulations and laws in the United States shall be interpreted in accordance with those policies. So it provides a statutory mandate for using this type of legal principle, that to the extent that there is any uncertainty or ambiguity in how statutes are to be read, that should be done considering environmental purposes into account as well. So this is broader than just saying whenever we have an environmental statute, we need to read it broadly or we need to construe it in a way that makes it most effective. That's part of the principle. But another part of it is anytime that you have another statute, like the Civil Action Act in Brazil, which was not limited to environmental interests, you also need to interpret that kind of statute in a way that best serves the interests of the environment. Now, one of the common concerns about this principle is how judges will know what interest best protects the environment. Now, this is an important challenge, and one of the ways in which it can be addressed is through better training and better programs for helping judges understand the issues that are associated with environmental law. That can be done by the parties that are involved in the case. Many times the parties that are bringing the case will be best suited in order to educate judges about what the environmental interests are that are at stake. It can also take place through continuing education programs or the formation of specialized courts that include particular infrastructure that helps develop judges' knowledge and capacity about environmental law. One of the other responses that I think best addresses this concern is that the principle in dubio pro natura is not so much a principle for when the environmental interests are ambiguous. It's more about when the legal concerns are ambiguous. So how do we interpret this law? Should we give it broad effect? Should we give it narrow effect? What implications might this statute that relates to some other area of law, whether it's criminal law or corporate law, what impacts might it have on the environment? Oftentimes, those environmental impacts are very clear, and what is not clear is the statute or the code that's being applied, or the law, or the guidance that's given to administrative agencies. So the first step for in dubio pro natura is really those types of cases. The environmental interests are clear. The parties that are involved in that can really give judges the tools that they need in order to understand what technical or scientific aspects might be in play. But to the extent that the law is uncertain or the statute is uncertain, then really that's the place where the principle comes into play. In addition to issues of statutory interpretation, another area where the principle in dubio pro natura can be applied is in shifting the burden of proof. So the default in most legal systems with regard to environmental matters may make it difficult in order to reach just results, because causation of environmental degradation can be often difficult to prove. However, when we apply the principle in dubio pro natura, when there is a basic showing of environmental degradation, the principle allows judges or other decision makers to shift the burden of proof, to shift the balance in order to ensure that environmental interests can be best protected, which is to say that once a showing of environmental damage has been made and there's at least some substantial evidence or reasonable means of connecting a particular party or a particular activity to that damage, then the burden then shifts on the other party in order to show that what has taken place, either that this environmental degradation has not been caused by that particular activity. So the burden shifts in the way that it also does with the precautionary principle as well. So with the precautionary principle, when there's scientific uncertainty about whether a particular chemical is hazardous or toxic to the environment or to humans, rather than needing to prove that the activity or substance is dangerous, the burden shifts to those who would use it, to those who would engage in that particular activity, to show rather the absence of danger or to show that something is reasonably tailored in order to not cause environmental degradation. So these are a couple of applications or ways in which the principle in dubio pro natura has come into play. As I've said at the outset, it's really an important counterweight, an important way of balancing interests that are related to the environment, because our existing systems up to this point have not really promoted adequately and secured environmental interests in the interests of future generations. So this is particularly important in jurisdictions where you have a human right to a healthy environment, or duties on the part of the state to protect the environment, but it's not limited only to those circumstances. But importantly, I think I would say this principle in dubio pro natura is not about construing statutes in a way that restrict rights. Although this may run up against rights to property, it may run up against concerns about criminal law as criminal environmental statutes are applied. It may run into other important interests. But the critical aspect of this principle is that environmental interests will be balanced against those. It's not the only value in our society, but it's something that really should be considered and needs to be considered on the same level as other interests that our legal system takes into account. So that's the key concept of the principle. Again, it doesn't mandate that environmental interests will always predominate, but it does mean that they need to be concluded and they need to be adequately considered and they need to adequately be balanced. So to the extent that judges or other decision makers find ambiguity or have doubts as to how law should be applied, the principle in dubio pro natura says that this needs to be done in a way that best protects the environment. So that's the principle. I encourage you to look at the IUCN World Declaration on Environmental Rule of Law to learn a little bit more about this, as well as the other principles that have been identified for better enhancing environmental rule of law. Thank you.